Imagine buying your dream home only to find out that your local council have a legal loophole which can determine and dictate what you can build, what blocks your view, or completely shift the rules of your neighbourhood. All because of a tiny dispute that happened years ago. Most people think property law is boring.
It is!
They think it's just dusty files and endless jargon. But here in the UK, one landmark case proved that a single legal oversight can cost you thousands, reshape local government powers, and completely alter what it is that you own when you buy a piece of land. This is the chaotic, high-stakes story of Ross versus Ashford Borough Council. A legal showdown that started off as a planning dispute and ended up redefining boundaries of government power. If you own a home, or want to buy a home, or just hate bureaucratic red tape, you need to know how this one case protects your backyard. Yes, hello, welcome to the channel. It is I, Chris, with a K. I hope everyone's well. And people still do it with a fucking C. Anyway, I digress. To understand how this absolute mess unfolded, we have to look at how planning permission actually works in the real world. Here in the real world. Usually the rules feel pretty straightforward. If you want to build an extension, convert an old barn, I don't know why I'm pointing over there because I don't have one, or change how a piece of land is used. You submit a plan to your local council. They look at the local development frameworks and they say yes or no. You pay your fees and everyone else moves on. But things start to get incredibly messy when the lines between promises and policies blur. Our story takes place in Ashford, a rapidly growing borough in Kent. Enter Mr. Ross, a private landowner with plans to utilise his property. Now, this wasn't just a petty disagreement over a garden fence or the height of a hedge. This was a fundamental battle over a concept called legitimate expectation. Yes, you heard that right. Legitimate expectation. Mr. Ross believed he had clear understanding with the local authority over what could be done. He had invested time, energy, money, serious money, based on how the council had historically treated these situations. But then, the Ashford Borough Council changed its mind. They shifted the goalposts, leaving Ross holding a very expensive, very useless piece of paper. And to appreciate the absolute chaos of this court battle, you have to understand the invisible war that handles these situations. Public law versus private rights. When you sue a regular person, say, I don't know, a neighbour who crashes their car into your wall, for example, that's a matter of private law. It's about torts, contracts, and personal damages. But when you take on a government body like the council, you step into the arena of public law. In public law, you're not usually just arguing that the council broke their contract. Usually there is no contract. Instead, you have to prove that the government council acted unlawfully, irrationally, or with procedural impropriety. I'm not going to tell you how many attempts that took me. When Ross versus Ashford Borough Council landed in the courts, the legal teams weren't just arguing about bricks and mortar. They were arguing about the administrative abuse of power. Ross's legal team put forward a powerful argument that the council had created a legitimate expectation. They argued that because of the council's previous conduct, policies and statements, it was fundamentally unfair and therefore unlawful for them to suddenly pivot and veto the plans. But the council's legal team fired back, and to be honest, they fired back with a defence that should terrify any property owner. They argued, "We are a public authority. Our primary duty is to the public interest and to the public interest changes. A past stance cannot tie our hands from doing what we think is right for the borough today. Public interest trumps your private property goals." And if you're sitting there thinking, wow, that sounds like the government can do whatever it wants, as long as they shout, "Public interest!" you're hitting exactly why this case became a landmark. It went all the way to the High Court because the implications were massive. If the court ruled entirely in favour of the council, it would mean local authorities all across the UK could essentially make promises to developers or homeowners, wait for them to spend thousands of pounds on architects, surveyors, and then pull the rug out from underneath them without any legal consequence. It would create a system of pure unpredictability. On the flip side, if the courts ruled harshly against the council, it could accidentally freeze local governments in time. It would mean that a council could never update its environmental policies or housing strategies because they'd be legally chained to every offhand statement or minor policy they made in the past. The judges had to answer a massive question. Where does a citizen's right to rely on government consistency end? And where does the government's right to challenge its policies begin? The arguments got incredibly heated on whether or not the council's U-turn crossed the line on what the law calls conspicuous unfairness, which is a fancy legal term for acting so unfairly that it actually becomes an abuse of administrative power. So, how did High Court handle this difficult balancing act? Who actually won? The court's decision drew a strict historical line in the sand. The judgment made it clear that while local authorities absolutely have wide discretion to change their policies to match times, they cannot act with procedural unfairness. The court reinforced a massive principle in British administrative law. Local councils apparently are not untouchable. The ruling established that if a public authority's U-turn is so abrupt, so unreasoned, or so devastating to someone who reasonably relied on their word, the courts will step in and strike it down as an abuse of power. The council cannot just use the public interest as a get-out-of-jail-free card to hide arbitrary, inconsistent, or unfair behaviour. For Mr. Ross, this was a massive vindication. For the rest of the UK, it became a vital legal shield. It proved that the rules of administrative law, the rules are designed to keep government power in check, actually have teeth. It forced councils across the country to become far more aware, much more careful, transparent, more consistent in how they deal with everyday citizens. The legacy of Ross versus Ashford Borough Council lives on today. Every single time a new housing development gets approved or a homeowner fights back against an unfair local zoning decision, this case is acting in the background. It is the legal guardrail, ensuring that bureaucracy cannot simply override fairness. It teaches us a vital lesson. The law isn't just a set of restrictions designed to keep you back. If you know how to use it, the law is a tool to hold the power accountable. Let me know what you think in the comments below. Look after yourselves and stay out of trouble.